Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists dental associates with employment contract and independent contractor agreement issues. Today I'm talking about the risks of resigning without notice for a dental associate. So many times when I talk to a dental associate, they're extraordinarily unhappy with the practice that they're with. They want to get out as soon as possible, but they have this pesky thing called without cause notice. And it will simply state they have to provide the practice with a certain amount of notice and then work out whatever the notice period is, and then they're able to move on. Standard amount of notice would be somewhere between 60 to 90 days. And so their big question is, all right, I know that the contract says I have to give 90 days written notice. What if I don't want to? What are some of the risks associated with that? So let's kind of go through that. Well, first, some of the contracts will just definitively state what the penalty is. Most of the time, let's say you had a 60-day notice period and you only wanted to give 30 days notice. Well, most of the time the contracts would say you will owe that practice your daily rate for every day you would have worked during that 30-day period. So if you had a $1,000 daily rate and you were scheduled to work 20 days in the month, then you would owe them a $20,000 penalty if you fail to provide the full amount of notice. That's a pretty cut and dried example. Is if you just completely ignored that, it's very likely they're going to send you a nasty letter that says you're in breach of contract. You had to provide 60 days notice. You only gave us 30. The contract clearly states you're penalized this amount. You owe us $20,000. If you do not pay it, then we're gonna, take you to court. So that's a simple way of doing it. It's also relatively rare. I find many dental associate contracts are not that sophisticated. Sometimes the owner of the practice will try to do it themselves, and it just doesn't cover that scenario. So if it doesn't have a specific penalty, what are some things that could happen? Well, first, yes, you could be sued. You are in breach of contract. If it states you have to give 60 days notice and you don't, you're in breach of contract, and then they could come after you for damages. And so damages associated with the dental associate not giving enough notice would be, if they had to find a relief dentist, locum tenens dentist, anyone who's going to come in and fill any of the spots that you had, whatever it costs to pay that person, that would be something that could come after you for. Recruitment costs, credentialing, licensure, any of those costs associated with bringing in the new dentist could ultimately, be your responsibility. They could also come after you for lost profits. So let's say they're unable to fill your spot with any other dentist, and they had a full schedule. Well, they could say, look, we're going to make X amount of dollars. This dental associate flaked on us, and so those could be the damages that they come after you for. Now, what is the likelihood of doing that? It just depends upon the practice. Some dentist-owned practices are litigious and are not going to screw around when it comes to something like that. And others are passive and just kind of consider it just the cost of doing business and won't ultimately do anything. And then what the avenues are for resolving disputes also matters as well. There's kind of two ways that a contract dispute can be handled. Arbitration clauses are more and more popular than they were 10 to 15 years ago. And arbitration is simply where usually an attorney will hear both sides of a case and then render a binding decision. So you're not going to court, you're not doing a bunch of motion practice or filing fees. You're going to find an arbitrator. You'll have to usually split the costs of the arbitration, and then you would just kind of state your case, and then the arbitrator would render a decision and an award in this scenario. If there is no arbitration clause in your contract, then it would just be the simple litigation route. And so in most contracts, it'll state if there's a dispute, and if somebody wants to file suit, it's going to be in this county or this specific court or within the state. So if that was the route that the practice wanted to go, they would simply hire an attorney and then sue you and come after you for the damages that I spoke about earlier. There's not a great explanation where a dental associate can say, I'm absolutely can't give notice. Now, if there are some health concerns or some kind of tragedy involved in your family, then certainly you would hope the practice would understand and would take that into account. But just because you found a higher paying job and you want to leave immediately doesn't mean that if you do leave, you're going to get off, scot-free without any repercussions. And it's just unprofessional. You signed a contract, you agree to the terms of it, and then, if you're halfway into it and you say, you know what, I'm just going to ignore this, that's just not how contract law works. If you sign a contract with an employer and then halfway through your employment, they go, you know what, we're not going to pay you what we said we were going. We're going to pay you half. Well, if the language in the contract doesn't give them that freedom, then you certainly would be unhappy with that as well. So anyway, that's a little bit about resigning without notice for a dental associate. If you have any questions about your employment contract or independent contractor agreement, feel free to contact my law firm at the information below in the description. And I appreciate you watching the video. All right, thanks. Take care.